Okay, let's get into Chapter 6, Discovery and Financial Statements. The learning objectives for this chapter are to enable you to describe discovery, its nature, purpose, and scope in the domestic relations context, list examples of informal discovery in family law cases, identify the 5 formal discovery methods, describe the strengths and weaknesses of the various formal discovery methods, explain what e-discovery is and how the internet can serve as an information gathering tool, identify the kinds of objections that can be made to discovery requests, discuss the sanctions that can be imposed for failing to comply with discovery request rules and orders, explain how to locate and complete financial statements, identify ways of identifying and uncovering hidden assets, and describe the roles of the client, the paralegal, and the courts in the discovery process. So first, describe discovery, its nature, purpose, and scope in the domestic relations context. Discovery is the process of gathering information important to a matter at issue. It includes both formal and informal discovery, and in more recent years has come to include electronic discovery. The purpose of discovery is to gather as much information as possible about a case so that attorneys can make appropriate recommendations and clients can make informed decisions about their options. Because a failure to conduct discovery can have serious consequences for the client and possibly result in a malpractice action, the attorney should confirm in writing if the client will not authorize discovery. In an uncontested case involving no children and few assets, little or no discovery may be conducted beyond the exchange of financial statements. In complex and hotly contested cases involving many diverse assets, several children, and multiple states, extensive and costly discovery may be conducted. Information sought through discovery should not be protected by privilege and should be designed to lead to evidence that will be admissible at trial. What kinds of information are sought in family law cases? Early in a case, a discovery strategy will be proposed to the client, identifying the kinds of information needed, the techniques to be used, the sequencing of efforts, the assignment of tasks, and the projected cost. Information is commonly sought about the following: financial assets and liabilities, current income and expenses, financial and non-financial contributions to the marriage, dissipation of marital assets, employment history, parenting history, skills and weaknesses of both parents, marital misconduct if fault grounds for divorce are claimed or misconduct is considered in the context of spousal support and/or property division decisions. Examples of informal discovery in family law cases. Informal discovery involves information gathered not governed by specific procedural rules. Examples include searching public records, collecting bank account records and credit card statements, locating copies of income tax records, checking blue book values of vehicles, boats, etc., checking stock values, using a private investigator, interviewing potential witnesses, gathering copies of deeds, titles, registrations, making copies of electronically stored documents, emails, etc., if this is legally accessible. Many states have mandatory self-disclosure rules requiring the parties to automatically provide certain documents to each other within a limited amount of time, usually within 30 to 45 days, after the complaint for divorce is served. Mandatory disclosure usually includes documents such as the following: federal and state tax returns for 3 years, bank statements for 3 years, 4 most recent pay stubs, documentation of cost and nature of available health insurance coverage, statements for investment, retirement, and similar accounts for the past 3 years, copies of loan or mortgage applications for the past 3 years, copies of any financial statements prepared within the last 3 years. Identify the 5 formal discovery methods. What is formal discovery? Formal discovery is discovery that involves the use of 5 discovery methods that are subject to procedural and court rules. The 5 basic formal discovery methods are interrogatories, depositions, requests for admissions, requests for production of documents or things or for entry upon land, and requests for physical or mental examinations. Let's talk about the strengths and weaknesses of the various formal discovery methods. What are interrogatories? What are their primary strengths and weaknesses? Interrogatories are a method of discovery in which one party submits a series of written questions to an opposing party to be responded to in writing within a certain period of time under pain and penalty of perjury. The strengths of interrogatories are that they are cost-effective, They generate further discovery requests. They can identify potential witnesses, experts, physicians, etc. And the respondent has a duty to locate information necessary for response and to supplement their responses. The weaknesses are that they can only be used with the parties. They are reviewed by the respondent's attorney, so they reveal as little as possible to the requesting party. And the responses are written so they do not reveal respondent's potential weaknesses as a witness. What are depositions and what are their primary strengths and weaknesses? A deposition is a method of pretrial discovery in which one party questions the other party or a third person under oath. Oral or written responses to questions are reduced to writing for possible later use in a court proceeding. The reduction in writing of a deposition is called a transcript, and oftentimes paralegals will be asked to do transcript summaries or evaluations for use in appellate cases or in trial preparation. So be familiar with the term discovery or deposition transcript because it will come up in your work. The strengths of depositions is that they can be used with parties and non-party witnesses. So you can depose expert witnesses, just other character witnesses, anyone that they intend to call as a witness. Necessary information can be obtained more quickly. Performance of the deponent under oath can be assessed, so you can determine whether they're going to perform well on the witness stand or whether you are going to be able to draw out some of their weaknesses on the witness stand. You can follow up and clarify by asking questions if their answers are incomplete, evasive, or they open up a new topic. The weakness of depositions is that they are expensive. They may reveal the deposing party's theory of the case. They may reveal the deposing party's defenses. What are requests for admissions and what are their primary strengths and weaknesses? Requests for admissions are a discovery method in which a party makes written requests to an opposing party calling for an admission or denial of specific facts at issue or verification or denial of the genuineness of documents relevant to the case. The strengths of requests for admissions are that they are cost effective. They help to narrow the issues to be addressed at trial. They help to clarify disputed issues and confirm suspicions. And they help to reduce the facts or validity of signatures or documents needed to be proved at trial. The weakness is that they may reveal the requester's theory of the case and defenses. What are requests for production of documents or things or entry upon land, and what are their strengths and weaknesses? Request for production or entry upon land is a method of pretrial discovery in which a party makes a written request that the other party or a third person produce specified documents or other tangible things for inspection and or copying. The strengths are that they can be used with both parties and non-party witnesses. They allow a party to obtain critical information from entities such as employers and the IRS. They yield information that leads to further productive discovery. The weaknesses are that they can be expensive depending on the nature and extent of the production. What are requests for physical or mental examination and what are their strengths and weaknesses? Requests for physical or mental examination is a method of discovery in which one party requests that the court order that the other party, or in limited circumstances, a third party, submit to a physical or mental examination. The strengths are that they may lead to the discovery of otherwise privileged information. The weakness is that they can usually only be served on parties. They're highly intrusive and they may exacerbate conflict. And they usually must be sought by motion and good cause must be shown. So typically you have to file a motion with the court requesting that a physical or mental examination take place. Typically it's going to be the financial responsibility of the requesting party to pay the upfront cost of the examination. The court may divide that cost down the road, but it's going to be an initial financial output on the part of the party requesting the examination. And oftentimes, particularly in the domestic relations field, if a mental examination, for example, or psychological evaluation is going to be conducted, the courts sometimes I've had judges who will make those reciprocal. So if you request one, then you yourself or your client must submit to one as well. So they're tricky. They do exacerbate conflict. So it's best to use them sparingly and only really when you've got good cause to do it. or to make the motion, because typically if the court doesn't find really good cause for doing it, they're not going to grant the motion, and just simply putting the motion out there is obviously one way to further fan the flames of the conflict between the parties. So it's a tool to use sparingly. Explain what e-discovery is and how the internet can serve as an information gathering tool. What is electronic discovery? Electronic discovery is the discovery of documents in electronic form. It refers to any information created, stored, or utilized with computerized technology of any sort. The focus of e-discovery is on finding information stored in computers. The information can be sought from parties, employers, investment firms, friends, relatives, and others. It may be used to discover business records, personal records, cell phone records, etc. The rules regarding electronic discovery are evolving at both the federal and state levels, and in some states, e-discovery is governed by existing civil rules. How does the internet serve as an information gathering tool? The internet offers a rich variety of means to search for information about people and their interests and activities. Social networks like Facebook and MySpace, blogs and forums hosted by Google, Yahoo, and websites of various support groups, registries, records, and directories, some available for free and some at a nominal cost. Search engines such as Google, Yahoo, and Bing. You can take a look at Paralegal Application 6.10 on page 103 of your text for examples of how the internet can be used as an informal discovery tool. Identify the kinds of objections that can be made to discovery requests. Parties generally have a duty to respond to all discovery requests for which there is no legally accepted objection. Permissible objections are usually governed by procedural rules and common practice. The most common objections are: the request is unduly burdensome, the request seeks information or material that is not relevant to the issues in the case, the document, item, or information sought is not in the party's possession or control. The document, thing, or information requested is protected by a privilege recognized in the jurisdiction, such as attorney work product, doctor-patient privilege, etc. The information being sought is cumulative. The form of the question is improper. The request is being made solely for the purpose of harassment. Compelling a response would violate the respondent's Fifth Amendment right against self-incrimination. Typically, when you are in a deposition, for example, the job of the deponent's attorney, the job of the attorney for the person who is being deposed, in other words, is to raise objections when questions are asked that are objectionable. So in a deposition setting, you'll raise that objection, and then the client will still be instructed to answer the question. The reason for that is that there is no judge there to determine whether or not the objection is valid or invalid, and so that issue is an issue for trial if the same question is raised or that information is sought to be introduced at trial. The attorney would have to raise the same objection, but raising the objection in the deposition helps to preserve the record. But again, you'll see, if you get a chance to watch any deposition proceedings, you'll see the attorney make objections and then still instruct the client to answer the question. And that's the reason why, is that it's the trial court, it's the judge who is the gatekeeper of the evidence that comes in. And so it's ultimately the judge who has to make the determination of the validity of the objections made. Discuss the sanctions that can be imposed for failing to comply with discovery request rules and orders. What kinds of actions do courts take with respect to discovery requests? They may convene discovery conferences to resolve disputes and order a discovery schedule. They may issue protective orders when discovery is being conducted in bad faith, is excessive, or seeks privileged information. In response to a motion, they may issue court orders compelling compliance with discovery. If a party fails to respond to an order to compel, a court can hold him or her in contempt, award attorney fees to the other party, not permit the admission of certain evidence at trial, or in the extreme, stay or dismiss the case if the party in contempt is the moving party. Clients really don't like to turn over information, but what they like even less is having to pay the other attorneys legal fees for having to track down and chase down the discovery. So that's always the threat of an award of attorney fees is always a good one to notify the clients of if they are dragging their feet in producing documents. Also, from a from a practical perspective, if you have a client who is dragging their feet and not getting information into you in a timely fashion, it's best to put that in writing to the client saying we have a deadline of August 1st to comply with the discovery request. Failure to comply could result in sanctions, including a court order that restricts us from being able to introduce certain evidence at trial, an award of attorney fees to the other side, etc. Obviously, you would do that with the supervision of your attorney, but you want to stay on top of those things with respect to keeping track of deadlines and keeping your client informed. And you also want to preserve the record if sanctions are applied, and then you have a client who's upset because all of a sudden they have to pay attorney fees for the other side, and they try to argue that they weren't advised of the deadlines, etc. So best to put those things in writing if you do have a client who's dragging their feet on discovery, because it can be hefty sanctions for failure to comply. Explain how to locate and complete financial statements. A financial statement or affidavit is a party's statement of his or her assets and liabilities signed under pain and penalty of perjury. In some states, it must also be signed by the party's attorney. Financial statements are basically inventories of each party's assets and liabilities. They're designed to provide the parties with the information they need to make informed decisions. They also give the courts a frame of reference for making decisions with respect to matters of support and property division. Financial affidavits can now be located online in virtually all states and are also available in family courts. In many states, a financial statement is given to the defendant along with the summons and complaint for divorce. See Exhibit 6.4 on pages 197 and 198 of the text for an example of a financial affidavit out of the state of Connecticut. Now, previously, for a previous discussion board, you should have found the Franklin County Common Pleas Court website. On that website, in the domestic relations forms, you will see the form affidavits that have to be filed in the state of Ohio. These used to be different for every county you would file a divorce in. Every county had their own forms, their own layouts, their different information that they would request. It has been for some years now, they have been standard forms throughout the state of Ohio, which has really helped make the process more seamless and predictable in each county. You know exactly what's necessary, exactly what you have to produce, and exactly what you have to list on those financial affidavits. So take a look at those affidavits again. If you go to the Franklin County Common Pleas Court website, look for the Domestic Relations Court and look for the forms. There is an asset property division form, assets and liabilities, those types of things. Those are all of the things that have to be disclosed prior to having the case heard. They actually have to, when you file a divorce, you have to submit those financial forms at the time that you file. And when you file an answer, you have to submit your financial forms at that time as well. So it's information that is produced early on so that the court has an idea of the nature and extent of the marital estate, and both parties are moving forward, at least with a general understanding of what the extent of the marital estate is. Financial statements are very important documents and must be completed carefully and accurately. Often several successive versions may need to be prepared if the case does not conclude quickly. Inconsistencies must be able to be explained. Depending on the financial, organizational, literacy, and record-keeping skills of the client, as well as the complexity of the marital estate, the client may complete the statements for review or may be assisted by members of the family law team and sometimes also actuaries, who are individuals who would value pensions and other marital or separate property items that don't have a finite dollar value to them, and accountants and experts to value businesses and other such assets. You can take a look at Paralegal Application 6.11 on page 199 for pointers on the completion of financial affidavits. Oftentimes we will have paralegals sit down and go over the financial affidavits with the clients just to make sure that the numbers add up, that the client's budget that they have listed is not completely out of line with what the income of the parties is, etc. Identify ways of identifying and uncovering hidden assets. What are some of the ways in which parties hide or secret away or use marital resources for their own advantage? They transfer assets to family, friends, or paramours. They set up custodial accounts for their children. They postpone receipt of bonuses and commissions, etc., until after the divorce. They have a business and make payments to friends and relatives for work that was not actually performed. They keep cash, precious metals, and other valuables in safe deposit boxes. They make substantial and unexplained withdrawals from various accounts for unknown or unexplained purposes. They accumulate substantial vacation and sick time during the marriage for which they later will be paid. They make sham loans to family and friends. They receive unacknowledged perks at work, such as parking, travel, food, and housing allowances. They hold unregistered bonds or valuable unexercised stock options. What are some of the best resources for detecting these hidden assets? Tax returns, bank statements, credit card statements, financial statements, public records, mortgage applications. The family law team looks especially for inconsistencies among the above, and sometimes a forensic accountant may be retained to analyze and present evidence at hearings or trials. The forensic accountant's job is to trace these assets and find out where money either came from or went to, and to track and trace those assets. Describe the roles of the client, the paralegal, and the courts in the discovery process. What are the roles of the client and the family law team in the discovery process? The client and the family law team work together during the discovery process, with the paralegals and the client's extent of involvement depending largely on their skill levels. All of the tasks the paralegal performs are completed under the supervision of the attorney, and both the client and the family law team are constrained by law and rules of ethics. The major tasks performed by the paralegal include, among other things, drafting formal discovery requests, assisting the client and the attorney with drafting responses to discovery requests, participating in informal discovery efforts to establish values of selected assets, for example, running Blue Book values on cars or boats or other vehicles, looking up property values on the county auditor's website, etc. Paralegals also assist the client in preparing their financial statements. They conduct internet searches for information about both the client and the opposing party. So that is discovery, a very brief summation of discovery. You now should be able to describe the nature, purpose, and scope of discovery in the domestic relations context, list the examples of informal discovery, list the 5 formal discovery methods, the strengths and weaknesses of those 5 methods, explain what e-discovery is and how the internet can serve as an information gathering tool, identify the kinds of objections that can be made to discovery requests, also what kind of sanctions can be imposed for failure to comply with discovery rules, explain how to locate and complete financial statements, identify ways of identifying and uncovering hidden assets, and describe the roles of the client, the paralegal, and the courts in the discovery process. So that is it for Chapter 6. Stay tuned for Chapter 7. Thanks.